Ambrose presiding.
Thank you, everyone. You may be seated. Good morning. Good morning. Okay, we are here on case 530-885. This is State of Ohio versus Anthony Sowell, and Mr. Sowell is present with his attorneys, John Parker and Rufus Sims, also here. On behalf of the State of Ohio, Assistant County Prosecuting Attorney Rick Bombeck, Pinky Carr, and Lauren Bell. And we are here for sentencing in this case, ladies and gentlemen. And this is going to be a proceeding that's going to take I'll ask you first for your patience. Also, I do have to go over a few rules of decorum. Again, this is a sentencing hearing. It is a proceeding at law before a court. At some portion of this hearing, in this case, or the victims themselves, will be able to address the court. I want that to be conducted with all proper decorum and respect for this court and respect for the process of justice that has led us here today. All of you have certainly a lot of emotions concerning matters that have been before this court for the last 2 months and beyond. And I understand that, but you have to understand that we have a process here. It's been ordered. There's only been 2 little minor incidents with respect to anything regarding spectators. So I'll ask those of you, again, who are speaking on behalf of deceased victims to honor their memories and to certainly proceed in accordance with rules of just respect for all those that have gone before this court. With that, what I will do is review what the charges were, what the findings were, and then review with the defendant his obligations as a Tier 3 sex offender, as many of the counts included sexual motivation specifications. So some of the things that have to be done here today are proceedings, but must be done in order to have a proper hearing. So it will take some time, as I indicated. People will get their chance, but I just want to cover that in advance. I can't go through this proceeding without saying something, and I think we still have our video facility available on the 12th floor, so please be mindful of that. Okay, now as we get into the hearing itself, jury, as we know, and I certainly welcome the jury back for this proceeding. And again, thank you for your service on this case. But on July 22nd, 2011, the jury did return verdicts in this case, found guilty beyond a reasonable doubt of all but one of 82 counts in the indictment, along with the multiple specifications that were submitted to them. And of those verdicts, 21 were for aggravated murder. And for those counts, the jury found the defendant guilty of purposely causing the deaths of Tanya Carmichael, Nancy Cobbs, Shauna Culver, Crystal Dozier, Alicia Fortson, Imelda Hunter, LaShonda Long, Michelle Mason, Kim Yvette Smith, Janice Webb, and Diane Turner. And those were with prior calculation and design. And the jury and course of conduct specifications associated with each of those charges of aggravated murder. And the jury also found the defendant purposely attempted to kill LaTundra Billups, Sean Morris, and Gladys Wade. Jury also found the defendant guilty on the other charges, which were kidnapping in counts 3, 4, 9, 10, 15, 16, 21, 22, 27, 28, 33, 34, 45, 46, 51, 52, 57, 58, 63, 64, 67, 68, 74, 75, 80, and 81. Jury found the defendant guilty of abuse of a corpse in counts 5, 11, 17, 23, 29, 35, 41, 47, 53, 59, and 65. Also, the jury found the defendant guilty of tampering with evidence in counts 6, 12, 18, 24, 30, 36, 42, 48, 54, 60, and 66. Attempted murder, again, of Latundra Phillips, Sean Morris, and Gladys Wade in counts 69, 76, and 82. Felonious assault in victims in counts 70, 71, 77, and 83. And rape in counts 72, 73, 76, and 79. Also attempted rape in count 84. Now, that was the jury's verdicts on July 22nd. On July 27th, there was a bifurcated proceeding in this case. In other words, the defendant waived the trial by jury on certain of the specifications associated with the counts in the indictment, and the court did conduct a bench trial on those specifications. After a trial to the court found the defendant guilty of the repeat violent offender, sexually violent offender, and the notice of prior conviction specifications associated with the remaining counts of the indictment. The court then advised the defendant that the case would go forward to the jury for consideration during the sentencing phase. The defendant waived his right to a pre-sentence investigation, a mental health examination, but did exercise his right to make an unsworn statement at the sentencing hearing. Sentencing phase, the state reintroduced the evidence that it had introduced during the trial phase and then rested. The defense called 25 witnesses to the stand, including the defendant who gave his unsworn statement, and the state called 2 witnesses in rebuttal. The parties did submit to the jury for consideration at the close of all the evidence. On August 10, 2011, the jury found that the aggravating circumstances of the felony murder and course of conduct specifications associated with each count of aggravated murder outweighed the mitigating and returned a verdict recommending that the sentence of death be imposed on Anthony Sowell. And pursuant to Revised Code Section 2929.03, subsection F, this court must conduct an independent review of the facts and weigh the aggravating circumstances of felony murder and course of conduct against the mitigating factors that are obtained from all the evidence in this case. Before the court goes through its analysis, however, the defense or the defendant has the opportunity to be heard, and the defense has the opportunity to consider in mitigation of penalties. So at this time, I will ask Mr. Parker if the defense is going to make any comments or statements.
Jack, I don't think we're going to say anything other than we heard extensive testimony throughout the entire case. Obviously, we'd ask you to consider all the mitigating evidence, both from the first and second phase in making your decision. I also ask that you take into consideration that the client offered to plead guilty to the indictment before the trial, as long as the death penalty was not imposed. That was declined by the state. Guilty, he agreed to the maximum consecutive penalty. He agreed to make no appeals as long as death is not imposed. So I think that's something we can ask you to take into consideration.
Thank you. All right, and I also have to advise the defendant, Mr. Sowell, you have the right of elocution or the right to make a statement here before the court does proceed any further. Do you wish to make a statement to the court, Mr. Sowell?
I don't believe he wishes to say that.
Right. He's not going to make a verbal response to that?
Very saying
All right. All right, then, Mr. Sowell, I'm proceeding on the basis that you do not wish to make a statement. You've been advised that you have that opportunity. You have remained silent when the court has offered you that opportunity. And so we will proceed. Now, I do have to, before I go into my analysis of the facts, it is obvious, or it's necessary for me to review with the defendant his registration requirements. Again, because there are several rape charges here. There's also sexual motivation specifications for which the jury has found the defendant guilty of, and that does then classify the defendant as a Tier 3 sex offender. So I have to review with him the requirements as a Tier 3 sex offender before we can go any further. Now, as a Tier 3 sex offender, Mr. Sowell, you are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish into that county. If you establish a place of education in another state, but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. And employment includes volunteer services. You are required to provide the sheriff temporary lodging information, including address and length of stay if your absence will be for 7 days or more. After the date of the initial registration, you are required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. And if you do change residence address, place of employment, and/or place of education, you shall provide the sheriff with whom you most recently registered and or establish a place of employment and/or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address changes not to a fixed address, you shall include a detailed description of the place or places you intend to stay and no later than the day you obtain a fixed address. You must register with the sheriff for that fixed address, and you shall provide written notice within 3 days of any change in vehicle information, email address, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. Sex offender, you are required to register for your lifetime with in-person verification every 90 days. I'll ask counsel just to have the defendant sign this form. You can take the yellow copy on the back, and that will be as satisfied that the court has notified him of his registration requirements.
I don't think he's going to sign this.
All right, then I'll have counsel sign it for him in open court. Okay. Thank you. Now, going forward, again, in a capital case or death penalty case such as this one, the law requires that the court do an independent analysis of the aggravating circumstances and mitigating factors and weigh those against one another. The court does have the option of not following the jury's recommendation and imposing instead the only other penalty that can be imposed in this case, which was a life sentence without the possibility of parole. So the court is required to do that analysis. I have done that analysis and will review that for you now. First, the aggravating circumstances in this case that have to be weighed against the mitigating factors are, number one, that the offense of aggravated murder was committed while the offender was committing or attempting to commit or fleeing immediately after committing or attempting to commit kidnapping, and either the offender was the principal offender in the commission of the aggravated murder or, if not the principal offender, committed the aggravated murder. And two, that the offense was part of a course of conduct involving the purposeful killing or attempt to kill two or more persons by the defendant. Now, regarding these aggravating circumstances, the state introduced evidence during the trial phase, which was reintroduced during the mitigation. A reasonable doubt that the defendant, Anthony Sowell, purposely caused the deaths of 11 women over approximately 2.5 years. The state's evidence also established that except for one victim, Shonda Long, the defendant committed each aggravated murder while committing or attempting to commit kidnapping. County medical examiners Dr. Krista Pekarski, Dr. Frank Miller, and Dr. Elizabeth Balraj clearly established that the deaths of all 11 victims were homicides, and all but 3 were caused by asphyxia due to cervical compression. Trace evidence analyst Christopher Kern and Curtis Jones testified as to the various ligatures and bindings found around the bodies of 9 of the 11 victims, establishing the restraint element of kidnapping by direct evidence. The aggravating circumstances proved beyond a reasonable doubt, and the nature and circumstances are entitled to great weight in the process of weighing them against the factors in mitigation. And the mitigation factors considered by this court include the evidence presented at trial, the arguments of counsel, and the statement of the defendant. The relevant factors identified in Ohio Revised Code section subsection B, and any and all other information and reports that are relevant to the nature and circumstances surrounding the aggravating circumstances, including, but not limited to, the history, character, and background of the defendant. And during the mitigation phase, in addition to the various witnesses testifying as to his history, character, and background, the defendant also introduced the testimony of Dr. Dale Watson, a neuropsychologist, and Dr. George Woods, a neuropsychiatrist. And their testimony concerned whether at the time of the offense the defendant, due to a mental disease or defect, lacked substantial capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. The defendant also offered as a factor relevant to the issue of whether the defendant should be sentenced to death, the records expert and former Marine to describe the defendant's performance and career in the United States Marine Corps. Defendant's mitigation expert, Lori James Towns, also testified about the defendant's social history and background, as will be discussed further. The defendant's mitigation determining whether the aggravating circumstances outweigh the mitigating factors. First, the court reviews the circumstances surrounding each of the aggravated murders of the 11 victims, and this is solely to determine the presence of any mitigating circumstances. The aggravated murders murder for each victim, or murders collectively, are not considered part of the aggravating circumstances relating to a particular victim. Nor does the court give the aggravated murder, the individual aggravated murders, any weight against the mitigating factors presented in this case. But going back through that evidence, the first person to disappear in this case was Crystal Dozier. She was last heard of on May 17, 2007. Her body was found almost 2.5 years later, buried in a shallow grave in the backyard of 12205 in elaborately wrapped in multiple layers of heavy-duty plastic sheets, which were held in place with duct tape and electric cable. There was a cloth fabric ligature wrapped tightly around the neck, and the hands were bound at the wrist and held above the head. The ankles were bound with wire cables. The body was nude. The cause of death as asphyxia by cervical compression due to ligature strangulation. And Crystal Dozier's death was ruled a homicide. Tashana Culver was last seen sometime in March of 2008 in the crawl space next to the south bedroom of the third floor of 12205 Imperial Avenue on October 30, 2009. The body was wrapped in multiple black plastic bags secured with gray tape in the center and was covered with dirt. The body was clothed in a t-shirt, dress, pants, and socks. Autopsy revealed a knotted rope binding the wrist and a fractured hyoid bone in the neck. The coroner ruled the death a homicide caused by asphyxia due to strangulation. LaShonda Long disappeared in the summer of 2008. The only remains of LaShonda Long that were recovered was her skull, which was found in a bucket in the basement of 12205 Imperial Avenue, and the cause of death was determined to be homicidal violence. Michelle Mason went missing in October of 2008. Her backyard of 12205 Imperial Avenue, and the body was wrapped in 2 black plastic bags, a black comforter, a discolored orange blanket, and additional black plastic bags with gray tape in the center. There was a cloth ligature secured with a loop and a knot around the neck, and the body. The coroner ruled Michelle Mason's death a homicide, with the cause of death asphyxia due to cervical compression caused by ligature strangulation. Tanya Carmichael was last seen alive on November 10, 2008. Her body was found in a shallow grave next to a bush in the backyard of 12205 Imperial Avenue. It was wrapped in clear plastic material. The body was nude. An electrical cord believed to be the charging cord of a cell phone or camera was wrapped tightly around the neck. The wrists were tied behind the body with a cloth ligature. The death was ruled a homicide, and the cause of death was asphyxia due to cervical compression caused by ligature strangulation. Gladys Wade came into court and testified that on December 8, 2008, she was walking towards East 116th and Kinsman to catch a bus when she stopped at the beverage store at East 120th. As she left the store, a person she identified as the defendant said "Merry Christmas" and began to follow her, attempting to strike up a conversation. She was continuing to walk toward the bus stop and not trying to get involved in that conversation when the defendant grabbed her from behind and began the driveway into 12205 Imperial. Ms. Wade testified that she passed out due to the choking and woke up on the 3rd floor of the defendant's house in a room with a Christmas tree. She began to scream, and the defendant then punched her and said, "Bitch, take your clothes off." A struggle ensued between Ms. Gay and the defendant, which eventually led to their tumbling, Ms. Wade and the defendant, which eventually led to their tumbling down the hallway and into a glass door, which shattered and then cut Ms. Wade's thumb. Ms. Wade escaped from the defendant's house and ran across the street. 911. The store owner refused, told her to leave the store because she was bleeding on the floor, and told her to use the payphone outside. The defendant then crossed the street, came into the store, and threw her the sweater that she had left at the house. Cleveland police cruiser. Officers did investigate, and an arrest was made. However, the defendant was released with no charges filed at that time because a city prosecutor deemed there to be no credible evidence. Kim Smith was last seen on January 17, 2008, in the backyard of 12205 Imperial Avenue, buried in a shallow grave and wrapped in 2 sheets of translucent plastic and 3 black plastic bags. There were no ligatures found around the neck, but the body had fabric twine bindings around the wrists, tied in front of the body and the ankles. The body was nude from the waist down. The death was ruled a homicide, and the cause of death was homicidal violence, type undetermined. Imelda Hunter was last seen sometime during the middle of April 2009. Imelda Hunter's body was found in a shallow grave in the backyard of 122 in multiple heavy-duty plastic garbage bags. And there was a ligature in the form of a shoulder strap from a handbag or carrying case wrapped tightly around the neck. The body was nude from the waist down. The death was ruled a homicide, and the cause of death was asphyxia due to cervical compression. Tanja Doss then came into court and testified that on April 21, 2009, she went to the defendant's house to watch the Cavaliers game, drink, and get high. The defendant was talking about his ex-girlfriend, Lori Frazier, and after taking a hit on a crack pipe, He grabbed Miss Doss by the throat, pushed her up toward the headboard of his bed, and began choking her. As he was choking her, the defendant said, "Bitch, you can be the next crackhead bitch dead up in the street with nobody give a fuck about you." Miss Doss testified that she had tears coming out of her eyes. The defendant then told her, "If you want to live, knock 3 times on the floor." After indicating that she did want to live by knocking 3 times on the floor, the defendant released her. The defendant then slapped her and said, "Bitch, shut the fuck up, take off your clothes." Miss Doss asked to go to the bathroom to look at her face, which was swelling. The defendant back in the room, she testified that she started to put her clothes back on. The defendant told her, "Bitch, nobody told you to put your clothes back on." In response, Miss Doss testified that she laid down on the side of the bed naked in the fetal position and cried herself to sleep. In the morning, she stated that the defendant acted as if nothing had happened. About her daughter needing her due to a sick child, and the defendant let her leave. Miss Doss did not report this incident to the police until after she became aware of bodies being found at 12205 Imperial Avenue. Nancy Cobbs was last seen. Her body was found wrapped inside 6 black plastic bags and a white blanket, and was lying on the floor of the south bedroom on the 3rd floor of 12205 Imperial Avenue. The body was nude from the waist up and had a 36-inch long shoelace wrapped 2 times around the neck, and there was also a sock tied around the neck. The wrists were bound by an 18-inch long shoestring. The death was ruled a homicide, with the cause of death asphyxia by cervical compression due to ligature strangulation. Janice Webb was last seen on June 21, 2009. Her body was found in Avenue under a pile of dirt located under the basement steps. The body was found in a plastic bag, nude, with a belt tied tightly around the neck, wrists bound in front by shoelaces, and a shirt tied around the mouth as a gag. The coroner ruled the death a homicide and the cause of death strangulation. Talisha Fortson. She disappeared in June of 2009 and was last seen by her daughter on June 3rd, 2009. Her body was found lying on the floor in the south bedroom of the 3rd floor of 12205 Imperial from the waist down, and there was a shirt tied around her neck as a ligature. Her death was ruled a homicide by the coroner, and the cause of death was asphyxia by cervical compression due to ligature strangulation. Diane Turner was last seen in late August, early September 2009. Her body was found lying on the floor of the south bedroom on the 3rd floor of 12205 Imperial Avenue, nude from the waist down and with a black plastic bag around her leg. There were 2 robes and a pair of black pants laying over the body. The coroner ruled her death as a result of homicidal violence of undetermined. Latundra Billups came into court and testified that on September 22, 2009, she went to the house at 12205 Imperial with the defendant to drink and get high. After smoking and drinking, the defendant told her to stand up and turn around. The defendant then put his hand on the back of her neck, kind of forceful, and she turned around and pushed him. She testified that at that point he hit her hard on the side of her face and told her to take off her clothes. She took off her pants and he forced her to lie down on a blanket spread on the floor. The defendant performed oral sex on her. Ms. Billups testified that she was crying. The defendant then made her turn onto her stomach and he penetrated her vagina with his penis from behind. As he was penetrating her, he put an extension cord around her neck and began to squeeze it until she could not breathe. She tried to struggle, but eventually passed out. When she woke up, she testified that the defendant looked shocked that she had woken up. He then told her that he was going to kill her and then himself because he knew he was going to jail. Ms. Billups assured him that he was not going to jail and then turned the focus onto her ripped sweater. The defendant then told her to come back tomorrow and he would pay her for the sweater. Again together at that time. Ms. Billups did seek treatment for her injuries and did report it to the police. After delays in communication between Ms. Billups and the police, a warrant was obtained for the arrest of Anthony Sowell. And while attempting to search police began the discovery of bodies at 12205 Imperial Avenue. Sean Morris also came into court and testified that on October 19, 2009, she did have a prior period of sobriety and met the defendant, went back to his house, and was smoking crack cocaine and drinking with the defendant. She did leave the house that morning, but then realized she left her ID back at the house. She went back to the house, hollered up to the defendant to throw down her ID. The defendant told her to come up and get it. As she entered the house and began walking up the stairs, the defendant grabbed her from behind, put her in a military chokehold, and dragged her upstairs to his bedroom on the 3rd floor. Once in the bedroom, the defendant told her to take off her clothes and get on the bed. He told her to lay on her stomach and then proceeded to violently rape her. While he was raping her, the defendant was talking about how he hated you bitches. He said, "Look at you, you've got a husband at home and you're out here in the streets." According to Ms. Morris, the defendant was saying, "That's why I testified that the defendant tried to penetrate her anus with his penis and she screamed. The defendant then started closing windows, and when he left the room to close other windows, Ms. Morris began to climb out of the window in the bedroom to escape, thinking that she could hang drop and perhaps only break a leg or twist an ankle. The room and saw Ms. Morris hanging from the window. The defendant tried to pull her back into the house. However, when the defendant realized he could not pull her back in, he shoved her down as hard as he could. Ms. Morris fell to the ground below, broke both hands, 8 ribs, fractured her skull, and experienced an aneurysm. The fall also rendered her unconscious. On October 29, 2009, Cleveland Police SWAT units entered the house at 12205 Imperial and found the bodies. The defendant was later arrested on October 31, 2009, Street near Mount Auburn Avenue, which is a few blocks from Imperial Avenue. The defendant gave the police a false name and indicated that he had been stopped the day before and cleared. However, when it was suggested that the police would run his fingerprints through their computer system, the defendant they were looking for. During the following extensive interrogation by Cleveland Police homicide detectives, the defendant could not identify any of the 6 bodies that had been recovered from his house at that time. He described dreams and that he choked them, and according to the defendant, he did this in his dreams to punish them.